Well, the Senzo Meyiwa murder case continuing at the North Gauteng High Court. The Bafana and Orlando Pirates goalkeeper and captain was shot dead at his then-girlfriend Kelly Khumalo's home back in 2014. eNCA Slindelo Masikane has been covering that for us, and a very interesting day in court yesterday, of course, but I imagine we would need some legal perspective to put it all into place for us. Lee, good morning.
Good morning, Gareth. Yes, we are outside the North Gauteng High Court, of course, where we're expecting the cross-examination of Sergeant Thabo Mosia to continue at around 10 a.m. this morning. But we ended proceedings yesterday in the midst of cross-examination after an application was made to have hearsay evidence admitted during these proceedings. But to give us more analysis and to unpack this, as well as the proceedings, I am joined by legal expert Marius du Toit. Thank you so much for your time this morning, sir. Just to give us a sense as to, before we got to the cross-examination, Mr. du Toit, we saw Advocate Zandile Mshololo essentially withdrawing her application for that special entry. And this was after a meeting with the judge in chambers. And it looked as though the judge was really concerned about the pace at which the trial is moving in.
Yeah, Slindelo, lovely to speak to you once again. I think what we have to remember is, of course, the court wants this matter to be over as quickly as possible. And the reality is that all these things, when you bring these interlocutory applications or when you make special entries, all this does is it causes a further delay of the proceedings. And you and I know there's been many delays thus far. To make a special entry, now normally when you deal in the lower courts, you would bring a review application, and in a review application, you would then say there was an irregularity in the proceedings or something happened peripheral to the trial itself that has an impact on your right to a fair trial. In the High Court, however, the process is different. There you have to make a special entry, and that special entry will then be adjudicated upon later on should you then lodge the appeal with the Supreme Court of Appeal. So the fact that she's abandoned it, I think there's nothing untoward about that. I think, Slindelo, what we can say to one another is the fact that this docket has now surfaced. Of course, it impacts on your client's ability to have a fair trial, but it's manna from heaven in respect of cross-examination, because you can try and cross-examine the witnesses and you can try and elicit all the admissions you can from that docket. So it would actually assist the defense greatly in the way they can defend their clients of the very serious charges that they are facing. So I think maybe a wise choice to say I'm not making a special entry.
Let's move on to the cross-examination now, Mr. du Toit. We then had another application by Advocate Mshololo to have hearsay evidence admitted. Of course, the state objected to this, but ultimately Judge Miller ruled in favor of Advocate Mshololo.
Yeah, so firstly, we have to say that hearsay evidence is inadmissible. Now, if you just look at hearsay evidence is evidence upon which the credibility of that evidence depends on a third party's testimony. So as a rule, the fact that you told 1,000 people what Marius did yesterday doesn't make it more truthful, because it depends on what you actually saw. You can't have those people testify. And that's essentially the principle behind hearsay evidence. However, there are exceptions to the hearsay evidence. And these exceptions are, one of them is that in the interest of justice, the court can admit it. If the witness is going to testify later on, you can say, I want it provisionally allowed. So the court has a wide discretion to allow hearsay evidence. Now, typically, when you as an attorney or advocate confront a witness with a statement of another witness, it's dependent on that witness later on in court confirming his affidavit, or at least sticking to his story. But nothing prevents you from confronting a witness with the fact that a witness, of which the docket has been disclosed to you and this statement was included in the docket, will say X, Y, and Z if he testifies truthfully to his affidavit, contradicts another witness that the state has called to testify. And with the state objecting to that, it was only proper for her to lay a basis. And this basis was to say, Judge, I want you to, in this instance, allow this hearsay evidence on the basis that it's the interest of justice that should permit to do so. So the advocate has done it absolutely within the lines of law of evidence. And, she treated it quite correctly. And I think the court allowed it quite correctly.
Thank you so much for your time this morning. That is Mr. Marius du Toit, Gareth, just giving us some analysis ahead of the trial resuming this morning at 10 a.m. We know, of course, cross-examination continues, and we're here for the next 2 weeks, Gareth. So at this point, you can see that Judge Maumela, like the rest of South Africans, is quite concerned with issues around the pace at which this trial is moving in, but seemingly he is able to get through to counsel in terms of those meetings happening in chambers in order for us to be at this point in the least. So cross-examination continues at 10 a.m. and of course we will be bringing those visuals live.
As we have been every day so far. Slindelo Masikane outside the court for us, back with you again later in the day as well. You can also get regular updates on Twitter. If you're not able to watch us here on DSTV throughout the entire day, you can get updates on our social media accounts at eNCA. You can also follow Slindelo Masikane.